the buyer has a duty to inform the seller of any issues related to financing that could affect their ability to complete the transaction. This duty is essential to maintaining transparency and ensuring both parties are aware of potential risks that could delay or derail the sale. Below are some common examples of financing issues that a buyer should disclose to the seller. Buyer's duty to inform seller of financing issues. 1. Contingent financing. If the buyer's ability to purchase the property depends on the sale of their current home or another property, they must inform the seller. This condition makes the buyer's financing contingent on the successful sale of another asset, which can impact the closing timeline or ability to close at all. 2. Loan approval, delays, or denials. If the buyer is aware that their loan application is being delayed, rejected, or if there are concerns that their lender might not approve the financing in time for the scheduled closing, they must inform the seller. Delays in loan approval can delay the closing and cause uncertainty for the seller. 3. Changes in financing terms. If the buyer's financing terms change during the transaction process, e.g., the interest rate increases, loan amount is reduced, or the type of loan changes, they must disclose these changes to the seller, especially if the changes make it more difficult to close. 4. Bankruptcy or foreclosure. If the buyer has filed for bankruptcy or is in a foreclosure situation that could affect their ability to perform on the contract, they are required to disclose this information to the seller. Bankruptcy may delay the transaction or require court approval to complete the sale. 5. Insufficient funds or down payment issues. If the buyer discovers that they do not have enough funds for the down payment or closing costs, they must inform the seller as soon as possible. This may affect their ability to close and could prompt the seller to consider other buyers. 6. Unqualified lender. If the buyer is working with a lender that is not reputable, does not have a track record of closing loans in a timely manner, or is not qualified to fund the type of loan needed for the transaction, they should disclose this concern to the seller. 7. FHA, VA, or conventional loan requirements. If the buyer is using a specific loan program, FHA, VA, etc., that has stringent requirements or limitations on the type of property they can purchase, e.g., FHA does not approve certain properties, the buyer must inform the seller, particularly if the property does not meet those requirements. Examples of financing issues. Sale of buyer's property. The buyer has not yet sold their current home, and the purchase is contingent on the successful sale of that property. If the sale falls through, the buyer will not have the necessary funds to complete the transaction. Denied loan application. The buyer's lender rejects their loan application due to issues such as poor credit history, insufficient income, or other risk factors. This prevents the buyer from securing financing for the new property. Bankruptcy filing. The buyer is in bankruptcy, and the bankruptcy court has not approved the transaction. This will require a court order to proceed, which may cause delays or even cancel the sale if the court does not approve it. Change in lender. The buyer's original lender pulls out, and the buyer must seek financing from another institution, potentially delaying the transaction or changing the terms of the loan. Down payment shortage. The buyer initially planned to make a 20% down payment, but finds they do not have sufficient savings or liquid assets to cover the required down payment and closing costs. Legal considerations. Duty of good faith. Both parties must act in good faith during the transaction process. If the buyer has knowledge of financing issues that may affect the sale, withholding that information could be seen as a violation of the duty of good faith and fair dealing. Material fact disclosure. Any financing issues that affect the buyer's ability to close are considered material facts and must be disclosed to avoid the possibility of canceling the transaction later or facing legal issues. By promptly disclosing any financing problems, the buyer helps ensure the process runs smoothly and avoids any surprises for the seller. Here are some examples of how job loss, legal judgments, and unexpected shortfalls can affect a buyer's ability to secure a loan. 1. Job loss. Impact on loan approval. A buyer's employment status is one of the primary factors lenders assess when determining a borrower's ability to repay a loan. A job loss during the home buying process can lead to financial instability and reduce the buyer's income. Without a stable job or sufficient income, the buyer may no longer meet the lender's income requirements, making it difficult or impossible to secure a mortgage. Example: a buyer loses their job right before closing on a home. Their mortgage lender reassesses their ability to repay and determines they no longer qualify based on their reduced income or unemployment status. As a result, the lender may reject the loan application or delay closing until the buyer secures new employment. 2. Legal judgments. Impact on loan approval. Legal judgments, such as a court order to pay a large debt, e.g., unpaid taxes, child support, or a lawsuit settlement, can severely affect a buyer's creditworthiness and financial stability. If the buyer has unresolved judgments against them, these debts can show up on their credit report, potentially lowering their credit score. Lenders typically view outstanding legal judgments as a significant risk, making it harder for the buyer to secure financing. Example: a buyer is applying for a mortgage and discloses that they have a pending legal judgment for unpaid child support. The lender may be concerned about the buyer's ability to pay off the judgment and still afford the mortgage payments. This can result in a denial of the loan or additional scrutiny in the underwriting process. 3. Unexpected shortfalls. Impact on loan approval. Unexpected financial shortfalls, such as an emergency medical expense, an unexpected large bill, or a major repair, can reduce the buyer's available savings for the down payment or closing costs. A lender will generally require the buyer to have sufficient funds in reserve to cover these costs. If the buyer encounters a financial shortfall, they may struggle to come up with the necessary funds, potentially leading to issues in securing the loan or completing the purchase. Example: a buyer has saved enough for the down payment, but then faces an unexpected medical emergency and needs to use their savings to cover the expense. With fewer funds available, the buyer may not have enough to meet the down payment or closing cost requirements, which could lead to their loan being delayed or denied. In summary, job loss can drastically affect the buyer's income and the lender's perception of their ability to repay the loan. Legal judgments may lower the buyer's credit score and raise red flags for lenders about the buyer's financial obligations. Unexpected shortfalls can deplete the buyer's savings, preventing them from meeting the necessary down payment or closing cost requirements. In all of these cases, the buyer's ability to secure a loan is jeopardized, and it is important for the buyer to disclose such issues early to the seller to avoid delays, cancellations, or potential legal issues later in the process. Lombardo v. Albu case law precedent. The Lombardo v. Albu case, 2006, is an important case in the realm of real estate transactions, particularly concerning the duties of buyers and sellers to disclose material facts and the implications of those disclosures. In this case, the Arizona Court of Appeals clarified the standard for a buyer's duty to disclose certain information that could affect the sale of a property. It also highlighted the potential legal consequences of failing to disclose material facts in a real estate transaction. The case involved a buyer, Lombardo, who entered into a contract to purchase property from the seller, Albu. After the transaction was completed, it was discovered that the seller had failed to disclose significant issues related to the property, specifically defects that would have impacted the buyer's decision to purchase it. Lombardo argued that the seller was obligated to disclose these material facts, including defects, under Arizona's real estate disclosure laws. The court in Lombardo v. Albu held that sellers are required to disclose any material facts about a property that could affect the buyer's decision. This includes issues like structural defects, environmental hazards, or other substantial factors that could make the property less valuable or usable. The court clarified that even if the seller did not have actual knowledge of the defects, they still had an obligation to disclose information that would have been discovered through reasonable investigation. This decision reinforced the principle that both buyers and sellers have a duty of transparency in real estate transactions. This case also touched upon the buyer's right to seek damages if they are harmed due to non-disclosure of material facts. The court made it clear that buyers can seek legal recourse for damages caused by failing to disclose material facts, which can result in a lawsuit for breach of contract or misrepresentation. The Lombardo case set a precedent for how courts would interpret disclosure obligations in Arizona, emphasizing that buyers have the right to receive accurate, truthful information before entering into a contract, and sellers must adhere to these requirements. Impact of Lombardo versus Albu. The Lombardo versus Albu case is particularly significant for real estate agents, buyers, and sellers because it reinforced the importance of disclosure in real estate transactions. It established that the failure to disclose material facts can result in serious legal consequences for the seller and can potentially void the sale or lead to a claim for damages by the buyer. The decision also highlighted that the duty to disclose extends beyond just the seller's knowledge. It applies to any material facts that could influence the transaction. This ruling has shaped the way agents approach disclosure and has prompted many sellers and buyers to be more diligent in ensuring that all material facts are fully disclosed to avoid potential litigation. Buyer's agent required to disclose information that the buyer is or may be unable to perform facts. The transaction is in escrow, and closing is scheduled in 7 days. The buyer has ceased all communication with the buyer's agent. He is not returning emails nor responding to text or telephone calls. The buyer's agent, therefore, went to the apartment where the buyer was living. The buyer did not respond to knocks at the door. A neighbor of the buyer suggested that the buyer was in jail. The buyer's agent is unable to confirm whether the buyer is in fact in jail. The buyer's agent checked with the lender and was advised that the buyer had been non-communicative for 2 weeks and had not provided the documents necessary to process the loan application or fund the loan. Issue: is the buyer's agent obligated to disclose this information to the listing agent? Answer: see discussion. Discussion: the buyer's agent should not disclose to the listing agent that the buyer may be in jail because the information cannot be confirmed, and it is the buyer's confidential information in any event. However, based on the 2-week passage of time with no communication from the buyer and escrow set to close in a week, the buyer's agent should disclose that the buyer is or may be unable to perform pursuant to the contract. AAC R4 28 1101 B2, Lombardo versus Albu, 199, Rs 97, 14P, 3D 288, 2000.